Hello and welcome to our September 2023 HR and Employment Roundup for employers, the first of the autumn. Now, I know you're thinking, if you're watching this today or tomorrow, it's already October. But the truth is, what I wanted to do was just hang on for the start of the Tory party conference, which started yesterday. I suspected it might throw something up, and of course it did, with the Chancellor, Jeremy Hunt, announcing £11 an hour living wage from April next year. So Jeremy Hunt announced that from April 2024 the living wage will increase to £11 an hour. That's the headline minimum wage rate, so that applies to most workers aged 23 or over. Moving on from the Tory party conference and the announcement, I thought there might be more actually, but that was pretty much it, I think. Due diligence training, sexual harassment. Just a reminder that the first of our due diligence topic for September was sexual harassment. If you didn't carry out the training in September, the material is still available. So due diligence training reduces the risk of a claim against you. It takes very little time and therefore makes perfect sense. Sexual harassment, it seems, is in the news pretty much daily. At the moment, you'll remember the McDonald's, the harassment coverage, and of course you'll remember that kiss, which eventually led to the removal of the Spanish FA's top man. We have a short video briefing for employers on the topic of sexual harassment. That can be accessed from the news pages of JCHR, which is our sister website for payroll and HR combined outsourcing, and you can see that through the link on the screen. We also include a set of tools and a video briefing in the client area of myHRdept. So if you're a retained client of myHRdept, go to the client area, go and pick out those tools and the video and just use them for your staff. There's a couple of emails to send. It will help you defend any potential claims of vicarious liability against you in the future. So I'll be bringing you some more due diligence training later this month. Keep an eye out on our LinkedIn pages for that. We'll let you know when it's available and what it's all about. As ever, I will say on the topic of due diligence training, larger and riskier employers will be expected to do more to build their due diligence defences. So if you're a larger employer or you're an employer with a higher risk of sexual harassment occurring, and that generally means that you've got younger female workers working with more experienced senior male counterparts, that's where the risk tends to come from, then you should talk to us about a more tailored due diligence training programme for you, and we'll be happy to put one together for you. Now, moving on to myHRdept developments. Last month I eventually persuaded our recruiter Jazz to appear on video, and that seemed to be the kiss of death, because this month I'm both sorry and pleased for Jazz to tell you that she's moving on from myHRdept to join one of our fabulous clients' internal recruitment teams. Now, I'm not sure if that client has announced it internally yet, so I can't say who it is, but the move represents an opportunity for Jazz, an excellent opportunity for progression for her, and so we give her our full support, and she will leave us at the end of October. Recruitment, however, doesn't stop, and we're still doing a lot of it. The HR team here have long been recruiting for HR vacancies via our sister company Recruitment HR, and the team, which includes former recruiters, including me for exec vacancies actually, will be happy to pick up other support vacancies too. So if you need to recruit a role, give us a call and we'll discuss the best way of going about that with you. As ever, our fee structure for recruitment is extremely affordable, and as an added bonus, you won't have to deal with commercial recruiters who are often more interested in selling you any candidate than in finding the right candidate for you. Okay, so I mentioned, I think last month, that fines for employing illegal immigrants are going to be steeply increasing. So here is the lowdown now, as I promised. There is potentially a prison sentence awaiting the worst offenders here. I don't think that's ever going to apply to anybody that accidentally gets a bit of their due diligence paperwork wrong. I think that'll be reserved for the criminal fraternity who engage in modern slavery and so on. But potentially there is a criminal sanction there for the worst offenders, the very worst offenders. Currently, the fines for employing someone that doesn't have a legal right to work in the UK run from £15,000 to £20,000 at the maximum. So 20,000 for repeat offenders maximum and 15,000 maximum for first offenders. That will increase to a maximum of 45 to 60,000. So a huge increase, really. I'm told these fines are going to be coming into place early in 2024, early next year. I don't know exactly when. I've read January, but I'm not entirely sure about that. I'll keep you updated as I find out. Slightly ominous quote there from the Immigration Minister who announced these increases earlier in the year. He said, "There's no excuse for not conducting appropriate checks, and those in breach will now face significantly tougher penalties." Great, thanks for that. So it's important we do get our due diligence right. I need to stress, these fines are not theoretical. At my HR department, we've known employers who've received fines of thousands of pounds, and in one case, even a relatively small restaurant had to pay nearly 10 grand, and that was for an innocent mistake on their due diligence paperwork. So I said last month, I'll say it again, if you haven't had an audit of your right to work evidence documents for your staff lately, the staff that you currently have, particularly if you've had staff turnover in recent months or years, then you should really consider asking my HR department to book in an audit for you in the course of the next few months. This is potentially a very expensive way to make an error. So anything we can do to reduce your risks, I think, is time well spent. Okay, so moving on to employment tribunal cases. We like to bring you cases that we think are interesting and things that we can learn from. This month we've got a couple of interesting cases. We'll start with our Ilana to give you a break from me. Now she's going to go and look at a case involving disability discrimination, slightly unusually, this one involving an employee with severe menopause symptoms. And after that, it'll be back to me for another case, this time concerning Lloyds Bank. And Lloyds rather overreacted when they fired an employee for asking a question in a training session. Next up, it's Ilana.
Hi, I'm Ilana Telfer and I'm one of the ER advisors. And this month I'll be looking at a case involving menopause discrimination. Now this topic is gaining attention, and for employers, understanding how this fits into existing discrimination laws is important. The case of Linsky versus Direct Line Insurance is instructive in this context. Under the Equality Act 2010, discrimination claims, including those related to menopause, can touch on several protected characteristics, such as age, particularly when menopausal or postmenopausal individuals are treated differently, sex, in instances where a woman faces less favourable treatment due to menopause, and disability, if menopause symptoms significantly affect an employee's ability to carry out the normal day-to-day tasks, they may qualify as having a disability as defined by the Equality Act. So what's expected from employers? If an employee's menopause symptoms classify them as disabled, employers might need to consider making reasonable adjustments. Now, these may include changing specific workplace practices or policies, making physical alterations to the workspace or equipment, or providing aids to assist the employee. Now, in this case, Direct Line was found by an employment tribunal to have treated Ms. Linsky unfavourably due to her menopause symptoms. Whilst the company did offer some support, the tribunal felt that more should have been done, such as abandoning the performance procedure, which had judged her as needs improvement, a category that denied her a pay increase, lowering her targets, or contemplating a change in her role. Now, Direct Line's actions, including the poor performance rating and cessation of sick pay, were viewed as discriminatory. Now, some learning points here are: be proactive. Consider seeking insights from occupational health or an employee's GP, especially if they're willing, as was the case here. Always think about alternative roles or responsibilities that might better accommodate an employee's needs. And when making a decision, ensure you can demonstrate how your choices are proportionate and necessary. Now, with a substantial award of over £64,000 given to Ms. Linsky, this case highlights the importance of understanding and acting on menopause-related discrimination. So what can employers learn from this case? Well, firstly, menopause symptoms that cause work performance to suffer could amount to a disability, where those symptoms cause a long-term adverse effect on an individual's ability to carry out normal day-to-day tasks. Aside from disability, other protected characteristics are potentially triggered by menopause, notably sex and age. Together with disability, this heightens the risk of taking detrimental action against an employee. Thirdly, employers should consider reasonable adjustments to account for a disability and should have up-to-date medical information to aid decision-making.
I'm Bill Lark, founder of myHR Department, and I lead JCHR's HR team. Now, we tend to like to do video versions of myHR Department's editorials, and this one is quite an interesting case. It's a case involving an employee called Mr. Borg Neil, who used to work for Lloyds Bank. Now, he attended a training session on race education, and in that session he asked about if he heard a racist term used by a person from an ethnic minority and that related to that ethnic minority, how should he react if he was the line manager? Presumably he thought no offence would be caused if the person making the comment was also from the same ethnic background. So he didn't receive a clear answer from the trainer, and he pressed ahead with his chain of thought, and this time he gave an example of a black person using the N-word. Although he didn't say the N-word, he used the full term in the training session. Now, he realised fairly quickly that he had upset people by using that word, and he immediately apologised. But it was still too much for Lloyds, and they dismissed him for gross misconduct for using offensive and racist language in the training session. The Employment Appeal Tribunal felt that Lloyds had rather missed the point and gone too far. They'd gone beyond the range of reasonable responses a reasonable employer could have expected to have applied to a situation like this one. The tribunal took into account that Mr. Borg Neils was immediately regretful and apologised repeatedly for making the comment. And they also took into account the fact that he had dyslexia and that tended to cause him to speak before properly forming his chain of thought. So as a result, Lloyds were found to have unfairly dismissed him and to have discriminated against him on grounds of his disability of course being his dyslexia. So could using the N-word in work amount to gross misconduct? Well, yes, of course it could, but employers always have to be mindful of the context. A well-conducted investigation might have concluded here that Mr. Borg Neil had used the word in the context of a training session in which race discrimination was the central topic. Having sensed his error, they may have also concluded that his immediate apologies were indicative that he hadn't really meant to cause offence. Of course, they might also have considered that he had dyslexia and the role that that might have played in his using the word in the training session. I also think it's relevant that the trainer in the session hadn't answered the question, which led him to search for another example, it seems. So is there any justification for Lloyds dismissing him in this case? Well, frankly, our HR team at myHR Department have struggled to understand how Lloyds reached the conclusion that this conduct amounted to gross misconduct. Now, all of our retained payroll and HR packages contain a bank of support hours, and our employee relations team would have been very happy to use those hours to investigate cases like this one.
Yes, Lloyds went properly in at the deep end on that one. I'm not quite sure what they were thinking. Well, that's pretty much it from us for this month, other than to remind those of you who are sponsors about the increasing cost of sponsorship visas, which actually takes effect from tomorrow, from the 4th of October 2023. So most work and visit visas are going to be increasing in cost by about 15%, not about 15%. And certificates of sponsorship will be increasing by at least 20%, meaning that a 5-year skilled worker visa can now cost £12,000. We have a practical article that we wrote a couple of weeks ago on how employers can protect some of their investment if the employee decides to leave. And you can read that article by following the link that's on screen there for you. That's it. See you later this month with another update and some new due diligence training material free for retained clients of my HR department or JCHR. JCHR, of course, which is our combined HR and payroll service. So those materials will be free for you to use if you are retained by either my HR department or JCHR under an HR or an HR and payroll contract. Have a good month. Bye-bye.